For today's story, we cover part 2 of a recent Ninth Circuit decision where a judge basically dissents from himself with hilarious results. Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn your subscription. For today's coverage, we're dealing with part 2. Yesterday, we covered part 1, and we read the judge's decision, which was very based. But this judge knows that all is not well, because they know that there's odds favor them being overturned. So they've gone ahead and saved the en banc court the hassle. They've gone ahead and just written the opinion the other way around, right? So they already know the en banc court's going to review them, and they know in all likelihood they're going to be reversed, because in 50 cases, reviewing the Second Amendment, either the Ninth Circuit or the Ninth Circuit en banc has ruled against the Second Amendment every single time. That's 50 cases since Heller that they've reviewed. 50 times the Second Amendment is lost. So this judge thought, what if I just, write the decision the other way around and save the en banc court time? Hilarious. So let's read a judge dissents from himself and throws his other judges under the bus while doing so. Let's get started with this. Judge Van Dyke concurring with himself. I agree wholeheartedly with the majority opinion, which is not terribly surprising since I wrote it. But I write separately to make 2 additional points. The first is simply to predict what happens next. I'm not a prophet, but since this panel just enforced the Second Amendment, and this is the Ninth Circuit, this ruling will almost certainly face an en banc challenge. This prediction follows from the fact that this is always what happens when a 3-judge panel upholds the Second Amendment in this circuit. We're off to a rousing start. Our court has ruled on dozens of Second Amendment cases, 50 by our count, to be quite honest, and without fail has ultimately blessed every gun regulation challenge, so we shouldn't expect anything less here. Yeah, I think we're 51 for 51 is where we're going. My second point is related to the first. As I've recently explained, our circuit can uphold any and every gun regulation because our current Second Amendment framework is exceptionally malleable and essentially equates to rational basis review. Our court normally refers to our legal test as a 2-step inquiry, although it may be better understood as a tripartite binary test with a sliding scale and reasonable fit, a test that only a law professor can appreciate. The sarcasm drips off the page in ways that I've only begun to appreciate. Given both these realities, that no firearm-related ban or regulation ever ultimately fails our circuit's Second Amendment review, and that review is effectively standardless and imposes no burden on the government, it occurred to me that I might demonstrate the latter while assisting my hard-working colleagues with the former. Those that know our court well knows that all of our judges are very busy, and it's a lot of work for any judge to call a panel decision en banc. A judge or group of judges must first write a call memo, and then, if the en banc call is successful, the en banc majority must write a new opinion. Since our court's Second Amendment intermediate scrutiny standard can reach any result one desires, I figured there's no reason why I shouldn't write an alternative draft opinion that will apply our test in a way more to the liking of the majority of our court. That way I can demonstrate just how easy it is to reach any desired conclusion under our current framework, and the majority of our court can get a jump start on calling this case en banc. Sort of a win-win for everyone. To explain this reasoning and assumptions behind this type of analysis, my alternative draft below will contain footnotes that offer further elaboration. Think of them as thought bubbles. The path is well worn, and in a few easy steps, any firearm regulation, no matter how draconic, can earn this circuit's stamp of approval. Here it goes. I love this judge very much. He knows that this will be reviewed en banc because it always is. He knows he'll be overturned because it always is. And so he says to himself, you know what I'm going to do? What if I just write a dissent to myself? Yes, what if I just write a dissent to myself? That way I can save the Court of Appeals en banc time. I'll have written their opinion for them to save everyone time. Background of a fake opinion that doesn't really exist, but it might in the future. The rapid onset of COVID-19 pandemic disrupted every facet of life across the globe and has claimed millions of lives. In the early days of the pandemic, when information was scarce and panic was setting in, governments were forced to take immediate action. Accordingly, the County of Ventura issued a series of health orders to slow the spread of the disease. These orders, among other things, required the immediate closure of all non-essential businesses, including firearm stores and firing ranges. You love it. You love it right away, right? Because he's like, how can we get it? I know, let's just start with the COVID, right? It was the COVID that did it. So that makes it all okay. Legal framework of a fictional opinion. The Second Amendment states a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Our circuit, like most of our sister circuits, have discerned from Heller and McDonald a two-step framework for analyzing the Second Amendment. At step one, our court looks to see if the challenged law burdens conduct protected by the Second Amendment by examining the historical understanding of the scope of the right. If the law is outside the historical scope of the Second Amendment or falls within presumptively lawful regulations, the law is upheld. A law that implicates a core of the Second Amendment right and severely burdens that right is subject to strict scrutiny with a footnote. All other laws are subject to intermediate scrutiny. And then it has a nice little footnote. We refer to strict scrutiny as a theoretical matter, a thought experiment really. Our court has never ultimately applied strict scrutiny to any real-life gun regulation. The sass is real. We begin by first deciding if the orders burden conduct historically protected by the Second Amendment. Such historical analysis is not easy, and the courts of appeal has spilled considerable ink in trying to navigate the Supreme Court's framework. Yet history suggests that delays in taking possession of a firearm was not considered a substantial burden on the Second Amendment. Quoting from Silverster, before the age of superstores and superhighways, most folks could not expect to take possession of a firearm immediately upon deciding to purchase one. As a purely practical matter, delivery took time. Our 18th and 19th century forebears knew nothing about electronic transmission. Delays of a week or more were not the product of government regulation, but such delays had to be routinely accepted as part of doing business. One would take note that this exact same logic would apply to the First Amendment. Perhaps slightly less so, but not that much less so, particularly as it took time for news to travel across the United States. So, yeah. Even with this history as a guide, however, we're unable to definitively rule on the historical predicate of the county's orders. The complexity and novelty of these challenges raised by the COVID are not easily mapped onto 18th or 19th century practices and understanding. Therefore, we elect to follow a well-trodden and judicious course of assuming, rather than deciding, the regulation at hand burdens conduct protected by the Second Amendment. There's a footnote. Here's the deal. Whenever we think that history helps us in upholding the challenge regulation, we're happy to rely on it on step one of our test. But most of the time, history either doesn't help us uphold the gun regulation, is indeterminate, or is just really hard to evaluate. So usually we skip over step one of our two steps test by assuming the challenge regulation burns the Second Amendment protected conduct. But that's okay, because the real beauty of our two-step test is it's amazingly flexible at the various stages of step two in balancing the government's asserted interest versus the claim impact on the core of the Second Amendment. So we don't have to worry about that pesky, uncomfortable step one. We'll just assume it's a problem. But no, never fear, step two is here to save the day. Outstanding. Let's continue reading this non-existent opinion, which may be coming to a court book near you. Assuming without deciding that order burdens the conduct protected by the Second Amendment, we now must determine what level of scrutiny applies. Again, this is determined by looking at how close the law comes to the core of the Second Amendment right and the severity of the law's burden of that right. We have explained that intermediate scrutiny is appropriate when a challenge regulation does not place a substantial burden on the Second Amendment right. Continuing on, here we cannot say the order imposes a severe burden on anyone's ability to exercise their Second Amendment rights. And there's a footnote. Severe is a very strong word and a real workhorse when italicized. Yeah. The orders only temporarily delayed the sale of firearms and use of firearms at firing ranges, which is a far cry from the complete and permanent ban of handguns as invalidated in Heller. A footnote. Another one of our favorite tricks. Once you frame Heller as speaking only to complete and total bans, it's easy to sidestep its holding. All a judge has to do is pretend the Supreme Court would have allowed anything short of DC's drastic prohibition in Heller, instead of viewing Heller as easily correcting an especially egregious constitutional violation. So yeah, we can read it as saying, oh, the line is here, as opposed to saying this case is so easy, we don't know where the line is. But we can misread it, no problem. We're good at that. Moreover, we've already upheld government regulations that result in temporary delay of an individual's ability to take possession of firearms under intermediate scrutiny. And here, as in Silverster, the regulation does not prevent, restrict, or place any conditions on how guns are stored or used after a purchaser takes possession. Finally, a delay in acquiring a firearm is hardly a foreign concept to California residents. Yeah, they're so regulated, what's one more? Which, is kind of one of the reasons that the Second Amendment people get a little bit upset with new regulations, right? Because then you can run into these arguments. It's already so regulated. What more do you care if it's more regulated? Which, at this point in California is not an argument wholly without merit. The right has become so diluted and so hollow. What's even more? Maybe this is a reason not to allow those in the first place, though. A cautionary tale, one might say. We conclude, therefore, that the orders do not severely burden any Second Amendment right implicating the core of the Second Amendment, so intermediate scrutiny is appropriate. Footnote 8. Whew, hard work done. It's all downhill from here. It's so easy, though. It's so easy. This is how to be a liberal justice, paint by the numbers edition. This is great, man. This is great. It's like, well, you guys are so predictable. I'll just write your opinion for you. And, although the sarcasm drips off the page, he's not far wrong. Let's continue reading more of this opinion that isn't really his opinion, but might be an opinion from the en banc court at some point in the future. Let's read more of this fake opinion. Applying intermediate scrutiny. We require the government's stated objective be significant, substantial, or important, and a reasonable fit between the challenge regulations and the asserted objective. The first prong is always met in Second Amendment cases. Guns are dangerous, after all, so the government's interest in ameliorating such danger is always important. At first, we were worried this case might be a problem, because these regulations here don't have any real nexus to the dangerousness of guns. But COVID-19 is dangerous too, so that substitutes in nicely. Just substitute in the dangerousness of COVID for the dangerousness of firearms and say it's important. The Supreme Court has stated, stemming the spread of COVID-19 is unquestionably a compelling interest, and petitioners do not claim otherwise. What petitioners do challenge is that the orders are not a reasonable fit within the stated objective of slowing the spread of COVID-19, since other stores remained open while firearm stores and ranges were closed. But this argument misconstrues intermediate scrutiny. The intermediate scrutiny test is not a strict one. We have said that intermediate scrutiny does not require the least restrictive means of furthering a given end. And then we have a footnote. We've really gotten a lot of mileage out of this concept. One might think that because the first prong, government important interests, will always be met in Second Amendment cases because guns are inherently dangerous, the reasonable fit part of this test would take on special significance. But thankfully, the opposite is true. We've been able to water down the fit part of the test for the Second Amendment cases to such an extent that many of our judges have been forced to distance our Second Amendment case law from First Amendment case law from which it was supposedly borrowed. See, for example, Duncan. To be sure, the First Amendment and Second Amendment differ in many important respects, including text of purpose, and the analogy is imperfect at best. So even though we're basically shooting the First Amendment in the foot, by analogy, that's okay. We can just distance the Second Amendment from the First. The orders in preventing employees and customers from interacting indoors during the COVID-19 pandemic clearly promote this country's interest in slowing the spread of COVID-19 more than if such orders were not issued. Plaintiffs argue that Ventura County failed to meet the standard because it did not offer any evidence connecting the spread of COVID-19 to firearms retailers or firing ranges. But this again places too great a burden on the county. Localities must always be allowed a reasonable opportunity to experiment with solutions to admittedly serious problems. And this is even more true when faced with a global pandemic. Especially in the beginning days of COVID-19 pandemic, the type of hard evidence plaintiffs demands was simply not available, or at a minimum, rapidly evolving. How so very great? How very great, man. It just drips off the page in huge chunks of stuff. It's the greatest thing ever and all. Yeah, it's great. It's great. Let's read more of this faux, not an opinion yet, but it might be an opinion someday. Like every locality in the United States, Ventura County was forced to rapidly respond to an unprecedented pandemic. As the death toll for its citizens continued to rise, the county temporarily closed firearm stores and firing ranges, but lessened and then eventually withdrew those restrictions when the pandemic allowed. Plaintiffs may disagree with Ventura County's decisions, but it's not our job, now with the benefit of hindsight, to dictate what orders we would have found best. Local officials should not be subject to second guessing by an unelected federal judiciary, which lacks the background, competence, and expertise to assess public health and is not accountable to the people. And then there's a footnote. Again, it doesn't matter much what we say here. Once we're allowed to effectively balance competing interests under the Second Amendment intermediate scrutiny, it's so easy justifying a regulation that we could easily delegate this part of the opinion to our interns. Which, a little bit of ouch, because I am. For those reasons, we affirm the district court's dismissal of the complaint for failure to state a claim. And then concludes this fictional, not an opinion, with the actual part of the opinion, which simply says, "You're welcome." Thus, that brings us to the end of the Court of Appeals case, or does it? Because an en banc surely will follow. In the case of McDougall versus Ventura, yes. In this case, we had an opinion from a judge, and we had a dissenting opinion from the same judge. Because he's like, I'm going to be overruled anyway. So since I'm going to be overruled anyway, why don't I just take the time to write the opinion to overrule me? It's so easy. It's so easy. I just take these parts and I plug them in, and presto bingo, I've got an opinion that overrules myself. So I've saved you so much time on banc court. Look at how much time I've saved you by just writing your opinion for you. You're welcome. I love it. Now, I would not be surprised if we see wide parts of this in an eventual opinion from the Ninth Circuit. So this is just a fortune telling. And I fear to tell you, my friends, that my crystal ball looks a lot like the judge's crystal ball. This is an opinion that will exist in the future. It doesn't exist now. So for the moment, we will laugh until it becomes real, and then we'll cry. And that, for the moment, brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.